If you have been following this case and your jaw has not dropped yet, wait until the end of this chapter. Subscribe right now, hit that notification bell, and leave a comment below telling us, did you see this coming? Because trust us, nobody did. The music never stopped inside the mansion. That was what the neighbors always said. Late into the night, past 2, sometimes past 4 in the morning, the lights blazed behind those towering iron gates on Star Island, Miami. The bass rattled windows 3 houses down. Limousines lined the private road like a procession of black beetles. Security guards with earpieces stood motionless at every entrance, their faces carved from stone, their eyes trained on everything and nothing at once. From the outside, it looked like the center of the universe. From the inside, according to those who eventually found the courage to speak, it was something else entirely. Sean Combs, known to the world as Diddy, Puff Daddy, Love, had spent 3 decades building one of the most recognizable empires in American entertainment history. Record labels, fashion lines, liquor brands, television networks, his name was stamped across industries like a signature on a contract. Forbes had celebrated him, presidents had shaken his hand. His face had appeared on magazine covers that lined the checkout aisles of every grocery store in America. But empires, as history has always shown us, are built on foundations, and foundations can crack. In November of 2023, a lawsuit was filed in a federal court in New York City. The plaintiff was Cassie Ventura, a singer and model who had been in a relationship with Combs for over a decade. The allegations contained in that lawsuit were not ordinary. They were not the kind of claims that get buried in legal footnotes or quietly settled between handlers. They described a pattern of behavior so systematic, so calculated, so deeply embedded in a structure of power and control that federal investigators, who later reviewed the filings, reportedly described them as consistent with organized criminal activity. Within 24 hours of the lawsuit becoming public, it was settled out of court. Cassie Ventura received an undisclosed sum. Sean Combs released a statement, his lawyers released another. And the world, briefly, moved on. And the FBI had already been watching, quietly, patiently, for months. The investigation, sources close to the case would later confirm, had been opened long before the public ever knew a case existed. It had grown from a thread, a single tip, a single name mentioned in connection with another case entirely, into something that required interagency coordination, federal warrants, and a team of prosecutors who specialized not in celebrity scandals, but in sex trafficking and organized crime. That distinction matters. It changes everything about how the story has to be told. In March of 2024, federal agents executed simultaneous raids onto properties linked to Combs, one in Los Angeles, one in Miami. The images that emerged from those raids traveled around the world within hours. Dozens of Homeland Security agents in tactical gear, helicopters, armored vehicles on residential streets lined with palm trees. His sons, who were present at the Los Angeles property, were briefly detained before being released. Sean Combs himself was not at either location. He was in the Caribbean. By the time the raids were completed and catalogued, investigators had reportedly removed significant quantities of evidence from both residences. The specific nature of that evidence would not be fully disclosed publicly for months. But sources familiar with the search warrants indicated that agents were looking for materials consistent with a federal sex trafficking investigation, not a civil dispute, not a financial crime, not a copyright violation, a federal sex trafficking investigation. The music that had played through the night for 30 years began, at last, to fade. And in a quiet federal building in Lower Manhattan, a grand jury had already begun to convene. But what investigators found inside one secured room of the Miami estate, locked, climate-controlled, and hidden behind a secondary wall, would stop even the most seasoned agents cold. When they finally got that door open, what was inside did not just build a case, it rewrote the entire timeline. The locked room in the Miami estate measured approximately 14 by 12 feet. It had no windows. The ventilation was independent from the rest of the property's system, meaning it maintained its own temperature regardless of what was happening in the rest of the house. The door was reinforced, fitted with a keypad entry system that was not standard residential hardware. It was the kind of lock you found in server rooms, in evidence storage facilities, in places where the contents were considered too valuable or too sensitive to leave to an ordinary deadbolt. Federal agents had stood outside that door for 20 minutes while a technical specialist worked through the override sequence. The lead agent on the Miami raid, a 15-year veteran of Homeland Security investigations who had worked trafficking cases from Eastern Europe to Southeast Asia, later told colleagues that in all her years of executing search warrants, she had never seen a residential room secured like that one. When the door finally opened, what they found inside was not weapons. It was not drugs. It was not cash. It was documentation, hard drives, external storage units, dozens of them, stacked and labeled in a system that suggested deliberate organization rather than accumulation. Physical files in archival boxes, notebooks, and recording equipment, professional grade, the kind used in studios and production facilities, that had been installed directly into the room as walls, connected to a server rack that hummed quietly in the corner. The agents photographed everything before touching anything. They worked methodically, cataloging each item with the precision that federal evidence protocols required. It took 11 hours to complete the initial inventory of that single room. What those hard drives contained would not be fully known to the public for months. But within the investigative team, the contents shifted the entire architecture of the case. What had begun as a sex trafficking investigation with a defined set of alleged victims and a defined timeline suddenly expanded. The recordings on those drives were not limited to recent years. They were not limited to one location. They were not limited, investigators would discover, to one category of crime. The lead prosecutor assigned to the case, a senior official in the Southern District of New York who had previously overseen prosecutions of organized crime figures and international trafficking networks, reviewed the initial evidence summary and immediately convened a meeting with her team. According to sources familiar with that meeting, her first words were direct and unambiguous. She said, "We are going to need more people." Back in New York, the grand jury that had been quietly convening since late 2023 received its first major evidence presentation in April of 2024. The session lasted 3 days. Witnesses who had been interviewed privately by federal agents over the preceding months were called to testify under oath. Some of them had signed non-disclosure agreements years earlier. Some of them had received payments, in some cases, payments of significant size that had been structured, prosecutors alleged, not as compensation but as containment. As silence, purchased and maintained through financial dependency and the ever-present threat of what would happen if that silence broke. Several of those witnesses had lived with that threat for a long time. When they sat in the grand jury room and spoke, some of them for the first time without legal restriction or fear of financial consequence, the testimony they gave added dimensions to the case that the documentary record alone could not have provided. They described not just individual incidents, but a system, a pattern of behavior so consistent across years and locations and victims that prosecutors began using a specific legal framework to describe it. Not isolated criminal acts but an ongoing criminal enterprise. The kind of language that invokes the federal RICO statute, the same statute used to dismantle the Gambino crime family, to prosecute cartel leadership, to take apart organizations whose power derived from institutional structure rather than individual impulse. By the summer of 2024, attorneys representing individuals whose names had surfaced in connection with the investigation were filing protective motions, requesting meetings with prosecutors, and in several cases, reaching out through intermediaries to discuss the possibility of cooperation. And then, in August of 2024, something happened that accelerated everything. A video surfaced, not through a leak, not through a hacker, through a legal process, a civil discovery request filed by one of the plaintiffs in the expanding web of lawsuits. The video had been obtained by a hotel's internal security system in 2016 and had been preserved through a documented chain of custody by an attorney who had been quietly building a civil case for years before the federal investigation became public. The footage showed Sean Combs in a hotel corridor. It showed what happened in that corridor. It showed it without ambiguity, without the possibility of alternative interpretation, without the kind of contextual uncertainty that defense attorneys rely upon to create reasonable doubt. Within 24 hours, it had become the most discussed piece of evidence in a criminal case in years. Combs released a statement apologizing for his behavior in the video. Federal prosecutors noted the statement publicly and said nothing further, because they had seen the contents of the Miami hard drives. They knew that the hotel corridor footage, as damaging as it was, represented one moment in one location on one night. What they had in evidence storage represented something considerably larger. 3 weeks after the video became public, a fourth civil lawsuit was filed. Then a fifth, then a cascade, numbers that required a dedicated docket to track. Each new filing added names, dates, locations. Together, they formed a pattern that no defense strategy could easily address. The architecture of the empire, built over 30 years with money and influence and carefully maintained fear, was developing fractures that ran from the foundation upward. And in a hotel in New York City on the evening of September 9, 2024, Sean Combs ordered room service, made several phone calls, and went to sleep without knowing that federal agents had already positioned themselves in the building. By morning, the indictment that had been sealed and waiting would be sealed no longer. The reckoning that dozens of people had waited years to see was, at last, approximately 12 hours away. The courtroom on the 14th floor of the Daniel Patrick Moynihan Federal Courthouse in Lower Manhattan was not large. For a case of this magnitude, that surprised people. Journalists who had covered presidential impeachments and corporate fraud trials worth billions of dollars noted that the room felt almost deliberately modest. Fluorescent lighting, wooden benches worn smooth by decades of defendants and witnesses and grieving families, a single American flag standing to the left of the judge's bench, its fabric barely moving in the recycled air. Sean Combs entered that courtroom on September 16, 2024, in a prison-issued khaki jumpsuit. The man who had once arrived at events in custom suits, flanked by a security detail that rivaled heads of state, walked through that door with his wrists restrained and his eyes fixed on the floor. He had been arrested 6 days earlier, on September 10, at a hotel in New York City. Federal agents had moved quietly, deliberately, with none of the theatrical force of the March raids. There were no helicopters this time, no armored vehicles. Just a small team of agents, a pair of handcuffs, and a 37-page federal indictment that had been sealed and waiting for the right moment. The language used by prosecutors was precise, clinical, and devastating. They did not describe a man who had made mistakes. They described a man who had, over a period of decades, constructed and maintained what the indictment called a criminal enterprise, a deliberate, organized system designed to recruit, isolate, and control victims through a combination of psychological manipulation, physical violence, financial coercion, and institutional power. The indictment referenced events spanning from the late 1990s through 2024. It named co-conspirators, some identified only by initials, whose own legal exposure remained in open question. It described specific incidents in specific locations, hotel rooms in Los Angeles, properties in New York, private events in Europe, with a level of detail that told investigators and the public something important. The witnesses who had come forward had not done so vaguely. They had come forward with dates, times, and documentation. Bail was requested. Bail was denied. Twice, the presiding judge, in denying the second bail application, cited the scope of the alleged conduct, the number of potential witnesses who remained in contact with individuals connected to the defendant, and what she described as a demonstrated pattern of using financial resources to influence and intimidate. The trial of Sean Combs was scheduled to begin in May of 2025. Prosecutors had indicated they intended to call dozens of witnesses. The defense filed a series of motions challenging the admissibility of certain recordings, seeking to exclude testimony obtained through cooperation agreements. Most of those motions were denied. What no one had fully anticipated was what happened 3 weeks before the trial was scheduled to begin. A cooperation agreement was filed under seal. A co-conspirator, one of those identified only by initials in the original indictment, had agreed to testify for the government. Prosecutors described the cooperating witness as someone with direct and continuous knowledge of the enterprise's operations across all relevant time periods. Across all relevant time periods, that phrase covered nearly 30 years. On the morning the trial began, the courtroom filled before dawn. Journalists from outlets across the United States, the United Kingdom, France, Germany, and a dozen other countries had secured press credentials. Legal observers, victim advocates, federal agents who had worked the case and were present not in any official capacity, but because they needed to see it through. The prosecutor stood, walked to the center of the room, faced the jury, and began. She did not begin with legal theory. She did not begin with the indictment's language. She began with a name, a single name. A person who had entered the orbit of Sean Combs' world more than 20 years earlier, young and hopeful and entirely unaware of what that world actually was. She told that person's story for 11 minutes without interruption. By the time she finished, 2 of the jurors were visibly struggling to maintain composure. The trial lasted 8 weeks. It produced more than 900 exhibits entered into evidence. It featured testimony from 31 witnesses, including 4 individuals who had signed cooperation agreements with the federal government. In its 8th week, a witness produced a document the defense had believed destroyed, a document that corroborated, with exact dates and exact language, the central claim at the heart of the government's enterprise theory. The defense asked for a recess. The judge granted 15 minutes. When the proceedings resumed, something had shifted in the room, subtle, irreversible. The jury deliberated for 4 days. On a Tuesday afternoon in late summer, they returned. The 4-person stood. The clerk read the counts. The courtroom was so quiet that the air conditioning, barely audible before, seemed suddenly loud. Guilty, 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 5 counts, all 5. Sean Combs sat without moving as each verdict was read. He stared at the surface of the table in front of him, at the wood worn smooth by decades of defendants, as the room around him absorbed the weight of what had just been decided. Outside the courthouse, on those same steps where a woman had stood quietly nearly 2 years earlier, the scene was different now. There were more people. Some were crying, some were embracing, some stood silently, alone, looking up at the building with expressions that were difficult to categorize, not quite relief, not quite celebration, not quite grief, but something that lived in the complicated space between all 3. One investigator, who had worked the early stages of the case, stood at the edge of the crowd and watched. When a journalist asked him how he felt, he was quiet for a moment. Then he said, "We knew from the beginning that the hardest part was not going to be finding the truth. The hardest part was going to be making people believe it was possible." The music, on Star Island and in Holmby Hills and in every room where the lights had blazed past 4 in the morning, had been silent for a long time now. But for the people who had walked into that world and struggled for years to walk back out, the silence was not empty. It was, at last, a beginning. They thought the empire was untouchable. They thought the walls were too high, the names too powerful, the money too deep. But the truth does not negotiate. It does not settle out of court. It waits. And eventually, it finds its way into a room with 12 ordinary people, and it speaks. If this story hit you the way we think it did, you are absolutely not ready for what is coming next. Subscribe now. Turn on notifications. Leave a comment below. What moment in this case shocked you the most?